Hi, welcome back to Space Thoughts. Today we're going to talk about an area in litigation or a case that actually was heard before the Supreme Court back in January and having a decision coming out probably in June, which is probably going to hold a lot of significance for non-governmental space in terms of the licensing of it in particular and the overall regulation of commercial space, particularly with the FAA, the FCC, the Department of Commerce, whatever powers they get to actually regulate commercial space. And we're going to go right to some of the slides I prepared on this. And I'm hoping not to get I'm not going to get too complicated on this because it is, it was a long case. The oral arguments were very long, and the material does get pretty dense. But what we're talking about is this case called Loper Bright Enterprises versus Raimondo. And essentially, what happened here is we have a fishing. This deals with the fishing industry and particularly the regulation of the fishing industry, where the Department of Interior is basically putting a lot of pressure on the commercial fishing industry through these idea of regulation. So the industry is pushing back now. This one in this case right here, Loper Bright Enterprises are pushing back on it and challenging this thing called the Cheveron deference, which is actually a case that was decided from 40 years ago in Cheveron USA versus Natural Resources Defense Council. And what the Chevron deference basically does, it creates a test whereby it gives the courts give administrative agencies like the FCC, the FAA, the Department of Interior, what have you, deference in interpretation of statutes, especially where they're vague. And the court in Chevron created this two-part test that we're going to look at here. Okay, under the Chevron deference, in step one, if Congress has delegated authority to the agency to decide a question, that is, if Chevron applies, the court asks at step one whether Congress directly addressed the precise issue before the court using traditional tools of statutory construction. If after applying those tools, the statute is clear on its face with respect to the issue before the court must implement Congress's stated intent. In other words, if Congress directly addressed this issue and is very clear on how this regulation, how the statute or how that statute should be created in regulation, the court has to look at that and give deference to the statute, what Congress actually intended. We talked a lot about this back in West Virginia versus EPA last year when I talked about this, and I'll actually link that video at the end of this video. So in other words, if an agency comes up and says that we're going to actually interpret the statute, if Congress gave clear intent, the court will give deference to the statutory authority. However, step two, if the court concludes instead that a statute is silent or ambiguous with respect to the specific issue, the court then proceeds to Chevron's second step. At step two, courts must defer to an agency's reasonable interpretation of the statute. Courts employ a variety of tools to determine whether an agency's interpretation is reasonable, including some of the same interpretive tools used in the step one analysis. Okay, if Congress hasn't specifically addressed this regulation or the statute, and Congress really didn't say what they wanted the administrative agency to do, then the court has to look at the agency's interpretation and determine whether it's reasonable. Now, it sounds easy on its face, but it gets very complicated in these litigation matters. What is reasonable? That's probably one of the biggest questions out there in your first year in law school. What's considered reasonable? So through that, Congress will actually, the courts will actually try and determine what the administrative agency thinks is reasonable. Let me give you an example. The FCC under the Communications Act really has no authority to actually regulate space debris. Congress did not address this. They didn't specifically go to the FCC and the Communications Act says you shall have the power to regulate orbital space debris. The FCC basically interpreted that on its own. Now, if that was brought before a court, the court would have to look at it and say, you know what, we just don't have the authority. You don't have the authority. So what means did you actually use to interpret the Communications Acts to give you this idea that you have the power to create regulations for orbital space debris? And then the court will do a balancing test, and if it decides, that the FCC's interpretation is reasonable, then it'll say, okay, you have authority to actually create or to actually regulate orbital space debris. On the other hand, and in most cases, from what I understand, basically the court will defer to the administrative agency when there's a question of its authority or ability to regulate if the statute is vague on this. let me give you another example. The National Oceanographic Administrative Agency, they have a statute about orbital space debris. It's actually given by Congress. So, in other words, if this was challenged, the court would actually go to step one and say, okay, we have a statute here, based on what Congress's clear intent. We decide that you and the court, that you, the NOAA, have the ability to create these regulations about orbital space debris, because, like I said, Congress is very explicit. We don't have to go to step two because there was no ambiguity. Congress decided you had this authority, had this power to do it. So that kind of gives you an idea of what the Chevron test does. Now, unfortunately, in a lot of cases, the administrative agencies, they do tend to give broad interpretations to the authority, quote, the authority that statutes give them. And oftentimes, because of Chevron, courts actually defer to the administrative agencies instead of the aggrieved party. So what's going to happen with this case in Loper is basically there is strong consensus, and I think you're going to see either a 5-4 or a 6-3 decision where the court actually destroys the Chevron deference. In other words, they're going to overturn a case that's been on the books for 40 years, that's been legal precedent for 40 years. What does that mean for commercial space? Well, in cases of the FCC, the Communications Act, they're going to have a hard time actually, in my opinion, defending the idea of regulating orbital space debris, even though they've been doing it for going on almost 20 years now. It's going to be a hard sell under a new standard, whatever that standard turns out to be. On the other hand, we have cases like people like NOAA, again, who actually have a statute for orbital space debris. They're pretty much in the clear anyways because they have congressional authority. Another one is the FAA, who's introducing their own orbital debris regulation. Again, I mean, without Chevron, they're going to have a hard time defending that in court because Congress has not given them any specific authority to actually regulate orbital space debris. So again, I don't know what the specific test is going to be. We're going to find out when they come out with a decision, probably in June. But again, a lot of commentators, a lot of people who watch these types of cases actually think that the Supreme Court is going to overturn it. And again, based on the oral arguments, it could be 6-3, 5-4, but I do think they're going to overturn it. And I think that's going to have significant play on commercial space going forward in terms of regulations, especially where, we have these competing views of what the future of licensing should look like, with Congress, with HR 6131, and the White House putting out its idea of regulations where we have two agencies and not just one actually doing the regulating for the licensing. So again, an overturned Chevron deference would actually be very helpful in terms of something like what the White House is proposing as opposed to Congress. So again, we're gonna have to wait and see what they actually do. But when the decision comes out, I'll read it and I'll come back and I'll do another video shortly after and follow up to show you what the court actually did and give you some ideas of what that means for non-governmental space activities. Until then, have a great day.